What are the requirements for drawing up a valid will in South Africa? What information will it require? Should you amend your will after a divorce? And why do you even need a valid will? In this video, we're going to answer these questions and other common questions that arise in the process of drafting up a valid will in South Africa. You are watching the Financial Metaverse. So why do you need a will? So everything that remains after you pass on, after all debts and administrative costs have been subtracted, will be inherited through the laws of succession by your qualified beneficiaries. If you fail to draft a valid will, the assets in your deceased estate will be distributed in accordance with the laws of interstate succession. If you want to know more about how the rules of interstate succession work, I'll encourage you to watch the video, What Happens When You Die Without a Valid Will in South Africa. I'll leave a link to that video in the description below. Dying without a valid will could result in an estranged spouse or an irresponsible family member inheriting assets that you would have preferred to bequeath to someone else. So if you want to ensure that your preferred people or organizations benefit from the assets that you leave behind when you finally pass on, make sure that you draft a valid last will and testament. The formalities of drafting a will are rather strict in order to avoid fraud and impersonation. These formalities are contained in Section 21A of the Wills Act 7 of 1953. They are relatively straightforward, but even a seemingly insignificant oversight may end up invalidating the entire document. Here are some basic requirements for drafting a valid will in South Africa. 1. The testator must be 16 years of age or older. 2. The testator must be mentally capable of understanding the consequences of his or her actions at the time that the will was drafted. Wills or provisions that are proven to be drafted under duress, undue influence, or mistake will be invalid. Convincing your father-in-law, for instance, to add you to his will after a couple of drinks of alcohol is generally frowned upon, and the relevant provisions may be challenged in court. The onus of proof to show mental incapacity or lack of intention on the testator rests on the person making such allegation. 3. The will must be in writing. It can be handwritten or printed. Just make sure it's clear, and don't forget to put your name on it. 4. The testator must sign at the end of the will. While the Act is not clear in this regard, it is recommended that the signature be placed just below or as near as possible to the last line of the will. A significant gap between the last line of the will and the testator's signature may be cause for a will to be declared invalid. Furthermore, the following methods of signature are sometimes necessary when the testator is paralyzed or is too feeble to sign. A testator may request a person to sign on his or her behalf. In such event, the signature must be made in the presence of the testator, at least 2 competent witnesses, and a commissioner of oaths. The Commissioner of Oaths must certify the will and sign each of its pages. A testator may sign a will by making a mark or a thumbprint in the presence of at least 2 competent witnesses and a Commissioner of Oaths. The Commissioner of Oaths must certify the will and sign each of its pages. Witnesses may not sign by making a mark or thumbprint. 5. If the will is longer than 1 page, the testator or someone on his behalf must also sign every other page of the will anywhere on the page. 6. The testator's signature on the last page must be made or acknowledged in the presence of 2 competent witnesses who are present at the same time. According to Section 1 of the Wills Act, a competent witness is anyone over the age of 14 who is of sound mind and capable of understanding the consequences of his or her actions and can testify in court. 7. The witnesses must sign the last page of the will. The signatures can be made anywhere on the last page, but it is recommended that they are made below or as near as possible to the last line of the will. The witness's role is to witness the signature of the testator or the person signing on the testator's behalf. It is therefore not necessary for the witnesses to read the will. 8. Although it is not a legal requirement, it is recommended that the witnesses also sign every other page of the will. 9. A beneficiary or executor should not sign a will as a witness. If they do, they may be disqualified from inheriting under the will. The validity of the will, however, will not be affected. 10. While it is not a formal requirement for validity, it is highly recommended to date your last will and testament to avoid any confusion in case more than one will is found. 11. Ensure that your original signed will is kept safe by a trustworthy person or institution, as a copy of a will not be deemed a valid will. Now that we've dealt with the legal requirements for drafting a valid will in South Africa, let's look at what information is required before you actually draft your will. 1. Make a detailed list of all your possessions. This includes all movable property like vehicles, jewelry, furniture, etc. All immovable property like your home, business, investment property, etc. And all your paper assets like cash in the bank, shares, unit trust investments, etc. 2. Make a detailed list of all your heirs. These are the people and/or organizations that you want to nominate to inherit your possessions. You will need to have full names, ID numbers, and the type of relationship you have with these individuals. 3. Decide on how you want to distribute your possessions among your heirs. This can be one of the most challenging aspects in the process of drafting a will, so one needs to give this very careful consideration. You need to be as specific as possible in your nomination. For example, Ivan Kumalo, my son, with ID number 8111155555085 will inherit the white Toyota Fortuner 2021 model with registration number ECC123EC. 4. Nominate your executor. This can be a family member, friend, professional, or institution. An executor is the person appointed to see to the administration of your estate once you have passed away, and ensures that your wishes are followed as far as practically possible and your heir or heirs inherit as you have specified. This nomination should also be done with careful consideration, as administering an estate can be a complex process. 5. Nominate a legal guardian. If you have a minor child or children, you should nominate a legal guardian to care for your child or children. This can be a family member or friend. You'll need to provide the nominated person's full name and ID number. Failure to provide this information could lead to unnecessary delays in winding up your estate, confusion, family conflict or disputes, and even interstate succession. Once you have gathered the required information as stipulated, you are now ready to draft your will. When drafting your will, ensure that you are practical in your bequests and wishes. For instance, if you are married in community of property, 50% of your estate belongs to your spouse. As such, if you make a bequest that your child or children inherit your 50% share of the property that you actually lived in, this may create a family conflict, particularly if your wife and child or children don't see eye to eye. Your spouse may not want to share the house with your child or children, or vice versa, which may mean that the property may need to be sold in order for the 50% share that you wanted to leave to your child or children to actually be inherited by them, or the other party may need to buy out the other in order to ensure that your wish is actually fulfilled. When they are minor children, it is generally wise to ensure that their inheritance is left in a trust until they become majors, unless your spouse or nominated guardian is highly competent in managing financial affairs. This is done by stipulating in your will that the assets that are left to your minor children should be placed in a trust. This type of trust is called a testamentary trust. You will also need to appoint trustees to administer the trust in the best interest of the minor children. Think about it this way. If you were to leave hundreds of thousands or even millions to someone who has barely managed 50,000 in their life effectively, how long do you think that sum of money would take before it disappears and children are left destitute? I'm sure you've heard or seen of such stories before. As such, it may be prudent to nominate your estate as a beneficiary of your life insurance policies, so that that money is paid to the estate and then managed by the trust, as opposed to being paid to an individual who may not manage that money in the best interest of the minor children. And furthermore, it is wise to draft your will with the assistance of a certified financial planner, unless you know and understand the intricacies of estate planning. Simply put, estate planning is the process of arranging and managing your assets during your lifetime, so that when you die, your assets are transferred in accordance with your wishes. Estate planning can ensure that estate duty, taxes, and other estate liabilities are minimized as far as possible. Estate planning is also aimed at protecting the needs of your beneficiaries, especially where there are special needs involved. And the estate planning process generally starts with the drafting of your will. As you can tell, the process of drafting a valid will can be quite complex, but I hope the information contained in this video has given you a lot of clarity. If you have any questions or require more clarity about the process of drafting a valid will and/or estate planning, please leave them in the comment section below. And to be notified when I release more videos like this one, please be sure to subscribe and hit that notification bell. If you haven't done so already, watch out for this video.